The case stated. Paragraph 18. The outline facts as found in the case stated have been set out in the introduction. The district judge's findings followed a trial in which almost all of the prosecution case was in the form of admissions and agreed statements. Oral evidence about what occurred was given by one police officer, and police body-worn video footage was also shown. Paragraph 19. All the applicants gave evidence of their long-standing opposition to the arms trade and of their belief that there was evidence of illegal activity taking place at the DSEI arms fair, which the government had failed to take any effective action to prevent. The district judge found at para 16 of the case stated that, quote, all defendants described their actions as carefully targeted and aimed at disrupting traffic headed for DSEI arms fair. Most, but not all, of the defendants accepted that their actions may have caused disruption to the traffic that was not headed to DSEI arms fair. Conversely, it was not in dispute that not all access routes to the DSEI arms fair were blocked by the defendants' actions, and it would have been possible for a vehicle headed to the DSEI arms fair but blocked by the actions to have turned around and followed an alternative route. End quote. Paragraph 20. The district judge identified the issue for decision at para 37 of the case stated as being, quote, whether the prosecution had proved that the demonstration in these two particular cases were of a nature such that they lost the protections afforded by Article 10 and 11 and were consequently unreasonable obstructions of the highway. End quote. Para 21. He recognized that this required an assessment of the proportionality of the interference with the appellant's convention rights, in relation to which he took into account the following points. At para 38 of the case stated, quote, A. The actions were entirely peaceful. They were the very epitome of a peaceful protest. B. The defendant's actions did not give rise either directly or indirectly to any form of disorder. C. The defendant's behavior did not involve the commission of any criminal offense beyond the alleged offense of obstruction of the highway, which was the very essence of the defendant's protest. There was no disorder, no obstruction of or assault on police officer, and no abuse offered. D. The defendant's actions were carefully targeted and were aimed only at obstructing vehicles headed to the DSEI arms fair. I did hear some evidence that the road in question may have been used at the time by other vehicles than those heading to the arms fair, but that evidence was speculative and was not particularly clear or compelling. I did not find it necessary to make any findings of fact as to whether non-DSEI traffic was or was not in fact obstructed, since the authorities cited above appeared to envisage reasonable obstructions causing some inconvenience to the general public rather than only to the particular subject of demonstration. E. The action clearly related to a matter of general concern, namely the legitimacy of the arms fair and whether it involved the marketing and sale of potential unlawful items, example those designed for torture or unlawful restraint, or the sale of weaponry in regimes that were then using them against civilian populations. F. The action was limited in duration. I considered that it was arguable that the obstruction for which the defendants were reasonable only occurred between the time of their arrival and the time of their arrest, which in both cases was a matter of minutes. I considered this since, at the point when they were arrested, the defendants were no longer free agents, but were in the custody of their respective arresting officers, and I thought that this may well have an impact on the issue of willfulness, which is an essential element of this particular offense. The prosecution in both cases urged me to take the time of the obstruction as the time between arrival and the time when the police were able to move the defendants out of the road or from below the bridge. Ultimately, I did not find it necessary to make a clear determination on this point, as even on the Crown's interpretation, the obstruction in Ziegler lasted about 90 to 100 minutes. G. I heard no evidence that anyone had actually submitted a complaint about the defendant's action or the blocking of the road. The police's response appeared to have been entirely on their own initiative. H. Lastly, although compared to the other points, this is a relatively minor issue. I note the long-standing commitment to opposing the arms trade that all four defendants demonstrated. For most of them, this stemmed, at least in part, from their Christian faith. They had also been involved in other entirely peaceful activities aimed at trying to halt the DSEI arms fair. This was not a group of people who randomly chose to attend this event hoping to cause trouble. End quote. Paragraph 22. The district judge's conclusion at paragraph 40 of the case stated was that on these facts the prosecution had failed to prove to the requisite standard that the obstruction of the highway was unreasonable, and he therefore dismissed the charges. The question for the High Court was expressed at paragraph 41 of the case stated as follows. Quote, the question for the High Court, therefore, is whether I was correct to have dismissed the case against the defendants in these circumstances. The point of law for the decision of the High Court is whether, as a matter of law, I was entitled to reach the conclusion I did in these particular cases. End quote. After this would be the decision of the Divisional Court, what they came to find and what their conclusion was for this case and how they looked at it. That would be from paragraph 23 to paragraph 28, I think. We will understand how they went about that. I hope you understood and enjoyed this, and thank you for watching or thank you for listening. Stay safe.